name is Shahara Wright, and I'm one of the speakers at Trademark That Thursday CLE. The event will be from April 29th to April 30th, 8 a.m. Central on Air Meet. Come make sure you join us. 5 great reasons why you should be there. 1 is that we'll have industry insights. 2, we'll have great networking with other attorneys. 3, MCLE credits. 4, meeting other attorneys. And 5, we got sponsorships and giveaways. It's going to be really a great event, and I'm looking forward to presenting to you licensing basics, how to use licensing to increase profits. We're going to have a lot of good things to talk about that day, but one of the things you're going to learn about is why licensing is important. Another thing you're going to learn about is what kind of licensing deals you can do for your clients. And the third thing you're going to learn about is what kind of information you need to have in your licensing agreement. Make sure you join my talk on April 29th, 2022 at 10 a.m. Central Standard Time. Look for more great information, and I look forward to seeing you there. Hi, everyone. I hope you can hear me. So I am Shahara Wright. I'm going to get started on my presentation. I am in a hotel. I'm at a CLE, and I came out to present a CLE. So we are doing all the things this morning, and I'm really excited to share with you. So I'm going to get started, share my presentation with you. Hold on. Oh, that's not what I want to do. Where is it? Okay, let me share my screen, and hopefully this will work. And then I'm going to show my presentation. There we go. So hopefully you all can see that. I cannot see the chat while I'm showing my presentation. So hopefully once I get through, I can answer your questions because I can't see the chat as I'm doing the presentation. So we're going to be talking about how to leverage your IP through licensing. I kind of changed the title because I thought that this was like a really better title that, to really talk about what we're doing in terms of leveraging your IP. It does increase profits, but I think it does a lot more than that. So I just wanted to let you know it's the same talk, just change the title slightly just because I thought it was more advantageous. So about me, my name is Shahara Wright. I'm a graduate, a very proud graduate of Hampton University. I graduated from there in 1995. I graduated from Texas Tech School of Law in 1998. And about 2 years later, not quite 2 years later, probably a little over a year later, I started my own practice called The Right Firm. I wanted to practice business law, work with small businesses and nonprofit organizations. I was unable to find a job. I applied everywhere. I worked for 2 solo practitioners doing family law and some general work. It just really wasn't what I wanted to do. So I started my own practice like a year out of law school. So I really just started representing small and mid-sized businesses, which is what I wanted to do. And since then, 23 years later, I'm still doing that. Now I really focus more on being general counsel for small businesses and nonprofit organizations. My clientele, their general revenue, their gross revenue kind of ranges anywhere between $1 million to $10 million in terms of revenue. What they do varies. So I represent lots of different types of entities. I know a lot of you probably focus primarily on trademarks. That's just a portion of what I do. A lot of the work that I do is contract based, so reviewing contracts, drafting contracts, mergers, acquisitions, restructuring, and that requires me obviously to touch on a lot of IP. And it also allows me to see a lot of different aspects of how IP is used and what other people want to use them for. So this is why I think that this is really important, because I even have these conversations with my clients about why they really should be leveraging their IP a lot more to get more bang for their buck, especially when they're talking about selling their business at some point. So I won't go over my whole bio because I really always find that that's just a lot, but you kind of here can see, who I am and what I'm about. And we're just going to go on to the presentation. Okay, so what is an IP license? IP license is a contractual agreement. It's basically to lease the intellectual property for a fee. So it's really a simple concept. You have IP, you want to allow somebody else to use it. You don't want to change over ownership. And so you're giving them permission to utilize it. It doesn't transfer ownership, but it gives limited use. And this allows the owner to benefit financially for long periods of times if they want, even if they're not producing the product or service. So it really can be a real financial benefit to the licensor, as we're going to talk about in a moment, that sometimes that they wouldn't really get this kind of passive residual income without them having to produce or manufacture, and that could be a very good benefit for the overall company or the individual IP holder. Okay, so licensing IP can create passive income for the IP owner. It can expand the brand. It can access new customer base, create a new business opportunities, enable businesses to enter new markets or industries. So these are all kinds of things that licensing your IP can do. I know I have these conversations with my clients to get them to think about it a lot more, especially with creators. They kind of like to create new products from the ground up and start things. But I also think, hey, if we have IP, we should utilize it. There should be some value there, because it's an asset. And because it's an asset, it's kind of just like a house, right? That the more you put into it, the more you do to make it pretty, to keep it up, then the more valuable it will come. As well. So you can use it as your own individual home, but if you also use it as rental property, then the value increases even more. So I think that you have to kind of look at it that way, get your clients to kind of see what opportunities there are to increase the value of their IP. So I wanted to give you guys a couple of samples of how big brands use IP. I think it's really important to see this because I like to use the big brands examples because I think it makes things clearer for our clients to kind of see, hey, these are big companies doing it. Although you're not a big company, or maybe you are, these are ways that you can utilize it, and it kind of gives some different aspects. So, one thing I like is Betty Crocker and Hershey's. Betty Crocker and Hershey's kind of came together and created a new type of product. Hershey's is a candy producer, manufacturer. They have Reese's, which is also one of their brands. In top of that. And so they wanted to kind of expand how Reese's was utilized in that peanut butter chocolate taste. And of course, they don't do baked goods. Betty Crocker does. So they went to Betty Crocker and they were like, hey, we want to create this recipe. They want to create baked goods. You do this. How can we work together? So Betty Crocker came up with a method to create different goods. So cookies, cupcakes, you can see they have frosting, kind of all with that different candy bar, Hershey's, S'mores, Almond Joy. They're different brands that they have to be able to come up with these different baked goods. And so this is a licensing deal, right? Because Betty Crocker is the one that's coming up with the recipes. It's not Hershey's, but they're showing that they have these tastes that go along with it. And they're utilizing their brands to produce the actual product. And so what this does is, from a consumer standpoint, a consumer who loves Betty Crocker and always loves their recipes and the things that go say, hey, oh, they have this cool new Reese's cupcake mix, or oh, we have Hershey's brand frosting, and that's the best chocolate out there, so we're going to buy that. So obviously, people are seeing these brand names; they're going to buy this stuff, and it increases the revenue, obviously, for Betty Crocker, and it also creates revenue, passive revenue for Hershey's, but also increases the brand spread because they're seeing it in more than just a candy bar. So these are opportunities there that exist for brand owners, for IP owners. One of the things that I love is Basquiat. But John Michael Basquiat estate owns the copyrights to his drawings. If you know anything about him, he's an artist, a young artist that passed away a long time ago, African American artist. His paintings still sell for millions and millions and millions of dollars, but they sell on a private market. And when they sell, his estate receives obviously nothing, right? Because it's a tangible item, and so there's nothing to be received. But the estate still owns the copyrights to his actual paintings and drawings that he's done. And they have partnered or gone to what is it, Artistar to manage the IP. And Artistar has really just kind of gone, full out with licensing his artwork over a lots of different apparel. So you may see Basquiat stuff on a lot of different things, purses, Coach purses. With you can see there's a Japanese brand, Converse. There's lots of different places where you will see his artwork on apparel. And so this license, kind of apparel license, has, of course, kind of brought renewed focus onto his artwork, his life, and who he was, and his artistry. Is probably also in some kind of way increased the residual income that from the selling of the artwork pieces. So the people that own his art, it's still selling for millions of dollars. So it's kind of become a trend in those kinds of things. And one of the things I think is great about this licensing project that's being done is that the reason why the brands want this is because it's bringing in new customer base. So Coach, one of my favorite purse companies, has a license with Basquiat estate, and they have these really cute purses with his artwork. And so if you want to have that look, that makes you want to buy that. I have a friend who bought one of his one of his pieces on a Coach brand. She didn't even know what it was. She was just like, oh, this dinosaur thingy. But she thought it was cute. It was one with Coach, and that made her purchase it. So these are the kinds of things that brands are doing and buying up these licensing deals. And you see it a lot with Disney and things like that. But you can do that as well as put it on apparel and have your license on apparel. Another co-brand and licensing deal that I really like is the new partnership with Megan Thee Stallion and Popeyes. So Megan Thee Stallion combined with Popeyes to create a limited edition merchandise hottie sauce, right? So there's the sauce that Megan Thee Stallion worked with Popeyes to create. And they have this sauce that's now being sold throughout the Popeyes franchises. It's a special sauce. And then there's also merch with cups and t-shirts and sweaters and hoodies and those kinds of things, which is kind of the hottie merchandise brand that's only sold through Popeyes. They have 3 different limited editions that they're coming out with. They're on the first edition now. That'll end, and then they'll come out with another edition and another edition. And that's really kind of the licensing. So the licensing is not just Megan Thee Stallion's name and brand, but her Hot Girl Summer brand that she has with this hottie sauce that she's doing that gives that combination. And so the co-brand between Megan Thee Stallion and Popeyes has really kind of launched a kind of renewed interest in Popeyes. And so the reason why Popeyes would want to do it is obviously because she has a huge fan base, and the people that support her are going to want to come out and try this sauce. They want to come out and support her, and that gives a new kind of breathing of fresh air into Popeyes for Megan Thee Stallion. Obviously, it kind of expands her brands, but it also gives her some additional income as well without having to be the producer of the merchandise and the sauce and all of that kind of stuff. So these are some ways that you can see, again, unique ways to use your IP. And then lastly, which I know probably a lot of you see, is affiliate marketing. Affiliate marketing really is just an advertising model in which a company compensates a third party publisher to generate traffic or leads to the company's products and services. And so it really just gives kind of a way for people to sell other people's products. But there's licensing involved, which of course is, sometimes you have the trademarks, you have some copyright with the documentations and things like that that you may have access to. You'll have things like your graphics and all that kind of stuff. And so usually in an affiliate agreement, you'll have information about how these things can be used, who's owns them, who has the rights to them, those kinds of things. So it's a licensing as well, kind of a non-traditional licensing, but licensing nonetheless. A lot of times, though, what you'll find in affiliate marketing is that we don't have necessarily registered trademarks, and we don't have registered copyrights. So it's important to think about that, about since some of these things that people have access to are not registered, that we have to really consider how to word these documents to take take into consideration that things are may not be registered. Okay, so there's like really three main forms of IP licensing that each kind of give different rights. And they sound kind of just like what they are, right? There's an exclusive, which is means just kind of what it says, right? It's an exclusive license. It's for one particular company or one particular use, and so that no one else is going to have it in this type of thing. So that exclusion can be various different things. It means it could mean, for example, we'll not give it to another apparel company, or maybe we won't allow for another restaurant or whatever else. Maybe not no one else in Texas. That exclusion can be anything, but it's exclusive nonetheless to whatever it is that you're saying that exclusion is. A sole meaning that it's only one person that has, or one entity that has access to this. So that means that, we're only licensing it to this. You may see that a lot with toy manufacturers where they might license a patent or something like that, and it's only licensed to this particular entity for them to manufacture, and no one else is going to have access to that. And then, of course, a non exclusive, meaning any and everybody can utilize this IP, that the licensor has not excluded anyone for any purpose. And so they can continue to license to whomever. So you'll see a lot of those kinds of things happening. So before you get started, so I think when you have businesses come to you and talk to you about licensing, and I'm using this in the context of small businesses, non-sophisticated owners in this space, it's really important to get some information from them, because a lot of times they get very excited about certain deals and certain opportunities. And because they get excited about these deals and opportunities, they don't really flesh it out. And a lot of time and money can be wasted because a lot of questions haven't been asked, and a lot of things that they need to know before they get started down this path are not kind of fleshed out in that negotiation. So I think if they engage you early enough, it is important to really kind of understand these things, to know whether or not, when we get started with this licensing path, is this the right move that we want to do? I think you have to evaluate the company's values and mission. A lot of times, companies will come to license to other people Sometimes friends will be like, oh, it'd be great if we did this thing together. But it doesn't necessarily that the two companies' values and missions don't necessarily mesh. Not necessarily the people, the owners may get along, but the way that the company's functions and what they do may not really mesh. And so when you have two brands that come together, and one is really passionate about one thing, and the other one doesn't really care too much about that, then it can kind of create a bad taste in the mouth of the consumers, and that may not be a good mix. The purpose. What's the purpose of this partnership? What is it going to do? Is it a manufacturing deal? Are you trying to expand the market share? Is there a new product line being created? Like, we need to understand, like, why is this happening, so that you understand the type of agreement that you need to put in there, and what kind of clauses that you need to do. Another thing that has to happen is your due diligence. So this is so critical and so key. And I think that there's kind of two separate parts of this due diligence. One is the due diligence, kind of going back to the first point, which is the company values and missions. Like, what is out there? What's the perception of the company that you're going to be working with? What are people saying with their about this company? If you co-brand, if you license, if you put your IP on the company, what is that going to say about you, right? Because they're going to because customers will import that onto you. And the other way around, if you're a licensee and you're looking to license someone else's IP, you have to understand what those company values and missions are, and does that really fit with what you have going on and what you're trying to put out. So that's important. I think another part of that due diligence goes to your purpose, which is, can this company meet the requirements that you have and help you meet your own purpose? So that's something that's really important. So I think there's got to be some due diligence with regards to that. And we'll talk more about kind of more intricate aspects of due diligence in terms of financials and their ability to produce and all of those kinds of things. But some general due diligence kind of before you get into the weeds of the agreement is really important. And then lastly, not the last thing really, but one of the last things is enforcement. Like, do the parties have what it takes to enforce the agreement? Do they, do you have a CPA? Is there an attorney, a business advisor? Like, what structure exists within the company to ensure compliance? Sometimes you don't have any of those things. And I think when you don't have those things, it's important to explain to your client that those things are going to be necessary to ensure compliance. Because with licensing deals, you're talking about a lot of minutia, especially when it comes to money and accounting. And as the attorney, I don't do that, right? I tell people I don't do math. So we have to have a CPA in order to do that. There's just no way that the individual owner is going to have the time and energy to ensure compliance and make sure that they, dotted every I and crossed every T. When there's non-compliance, making sure that you're sending notice letters and saying, hey, this is not happening. This is not going the way it needs to be going. And when we talk more about other aspects of that, somebody has to be able to watch over that. And so there needs to be a team in place to ensure compliance with the licensing deal, or else it's going to fall apart and lawsuits will start. Okay, so I've used some of these terms. I just wanted to kind of go through a quick one just in case there's somebody out there that doesn't know what these terms mean. And this is kind of your first kind of look at licensing. So licensing is just basically leasing your IP to a third party. The licensor, sorry, I got a mistake on my PowerPoint right here. But the licensor is the owner of the rights to the IP. The licensee is the business who is seeking the rights to the leased brand. So the licensor is the owner, the licensee is the one who's leasing it. And then the royalty is just basically the money that is paid for the use of the license. Okay, so let's just talk about drafting and what that means and how that works for licensing. So obviously, contracts are going to look different. A lot of times people ask if they're standard agreements, and there really isn't a standard, right? There might be some industry standards depending upon the industry, but even that's going to look different depending upon where you are. I mean, at the end of the day, they're contracts. So there might be certain rules within a certain industry. There might be certain rules within a particular state. A lot of times these are going to be interstate types of agreements. So you might be dealing with one person in California and another person in Alabama, or it could be, law all over the place. So they're probably going to be litigated in federal court. So really what you're trying to kind of make sure that you do is you pick a choice of forum. So if it's going to be based on California law, that you can comply with at least that, even though it might be litigated in a federal court somewhere else. So it's just important to kind of understand that this is a contract, and general contract terms and responsibilities are going to apply. So I think one of the things that can become tricky is who owns the IP. So for those of you that do a lot of IP and do, of course, the registration of trademarks, sometimes the person who owns the IP and the person who uses the IP are not necessarily the same. So I had a client once that we were trying to do an IP licensing deal. We were all in the middle of the contract, and I was like, wait, who owns this IP? And the IP was owned by the individual. The one who was doing the licensing deal was another person, another company, and the one who was getting money was another company. And so it's like ended up being three different parties. We had to kind of parcel that out. And then there wasn't any license agreement between the individual who owned it and the people who were trying to, and the company which she owned that was trying to license. So we had to put all of that in place to ensure that this licensing deal was agreed to. So we ended up probably with about 3 or 4 different agreements in place just to make sure that this one licensing deal made sense. So you got to know who owns the IP, and you got to know who the parties are to the agreement, because especially with small businesses, they tend to kind of piecemeal things. And so you got to know who the parties are. A lot of times too, if you're dealing with national brands or national organizations, that they may have multiple formations, business entities that they have. So you may be dealing with their North American branch, or a Canadian branch, or their South American branch, or some particular country, or something like that. And so it may still be, ABC Company, but it may be ABC Company America, or ABC Company in Mexico, something like that. So you got to really know who the parties are. Make sure you name them correctly, so that the right people are responsible and you can enforce this contract. Because if you don't have that right, it's not going to be enforceable. I think another big thing is privacy concerns. I think this is really truly important when you're talking about affiliate programs or some service agreements. Sometimes, with products, it's not as big of a deal because these are shelf products and people are buying it and you're not collecting information. But when you have affiliate programs, or you have some service where you're collecting information about people, whether it be emails, names and addresses, whatever kind of data that there is, you got to really pay attention to that, specifically too, because in the U.S., while we don't have one, Privacy Act, there's a bunch of different ones. So lots of different states are starting to put in their own privacy data acts. You have, obviously some federal acts like HIPAA, and other ones, FTC, and all that kind of stuff that have privacy within that. So you really need to make sure that your licensing deals comply with privacy laws, and that you ensure that each party, whomever they are and whatever their responsibilities, does not violate any of these privacy laws that's going to come back and blow back on the licensor or the licensee. Marketing restrictions or requirements. Sometimes you have certain ways that you want the brand to be perceived, or things, how you want things done. So sometimes you're going to have these restrictions. So sometimes those restrictions are, we want to see the advertisement and approve the advertisement every single time. So that can be a bit onerous, but sometimes that's the case. Sometimes it's, well, we want our logo or brand to be placed here. It has to be this size, or it has to be this color, or this kind of thing. So you have to really make sure that you have these marketing restrictions or requirements to be thought about. Insurance requirements. So sometimes, you want to make sure, if it's a product, especially if it's a good, that you have insurance with regards to the product itself. And if something happens, but also maybe you might need insurance if something goes wrong with the contract, or there's some blowback or indemnity insurance. So you need to think about what kind of insurance needs to be put in place with regards to how this deal is being structured. So it could be liability insurance, it should be cyber insurance. There's too many insurance types to name. The insurance industry kind of parcels these things out. But it's important to kind of think about that and say, hey, what kind of insurance do we need to have to make sure that everybody's protected, and that if something goes wrong, there's money to take care of that. That goes to indemnification. This is really, I think, important to talk about. And sometimes I think it's glossed over as kind of like a boilerplate, but it really should think about, in terms of indemnification, what are you protecting and who are you protecting? That's really important, and really kind of give some extra thought about indemnification, and not just kind of have this blanket indemnification that if something goes wrong, you're going to protect me. Because sometimes you can cross this indemnification and it can go against some other term of responsibility in your contract. So you need to make sure that it lines up. Or that indemnification could also be something that's against another contract that your client may be into. So don't just treat that portion as boilerplate. Make sure you pay really good attention to how you word that indemnification to make sure that it fits the needs of the contract. And then assignability, mergers, acquisitions, change of management. Like, if, can this licensing agreement be assigned? Usually, they're not allowed to be assigned, but assigning a contract is different from a company being merged, a company being acquired, that there being some main change of management. So those things may affect the licensing agreement. So you need to really think about, in terms of your agreement, whether or not those things will be allowed, and if they are allowed, what happens. In the case of a merger or acquisition, what happens if the management that you were dealing with has changed, and now you have somebody come in? How does that affect the licensing agreement? So those are some things that you really need to think about. So what else is in a licensing agreement? So I am kind of one of these people that believe that we start with the end in mind. So termination is really important to me. So one of the first questions I ask is, like, when is this ending? How is this going to end? What happens? What does this look like when we get to the end? And so that's something that I think is really important for you to know and understand. And a lot of times people don't think about that. The clients just are like excited that they have this opportunity, but they don't really think about how to get out of it when things don't go well, or when it's just kind of reached the end of its life. So that's something that you need to talk about. Compensation. What is the payment around, and the timing of payments, right? So not just, we're going to be paying you $5,000 plus 3% upon the gross revenue, or any of that kind of stuff, but when, how, what are the accounting provisions, and all of those kinds of things. So compensation is more than just the dollar amount that you're getting, but it is really just about the timing of those payments based on what. So that can really get really intricate depending upon the nature of the deal. But I think the more specific that you are, the better it's going to be. And I'll just kind of throw this out there too, is that you want to be as specific as possible. I think, especially with licensing agreements, you have to really be very detailed, and spell everything out. And you can't leave things to assumptions, because the licensing agreements that go wrong are the ones that don't explain. And then when you have to go to court, you can't enforce it because you don't have things that are detailed and specific. So you want to be as detailed and specific as possible. Quality control. I think this is a big deal, and it has to go kind of with marketing and branding, in terms of that marketing, how you want the marketing to go. But it's a little bit more to that, which is, if you're going to put my logo on a shirt, then this shirt needs to be of certain quality, right? This shirt needs to have a certain standard, for my logo to go on there. So you want those types of things. When we're talking about quality control of the product. If you are selling a book, I'm just using this for example, that the book has to have a certain measurements or standards or things like that. And how do you control that quality? So it's not just me putting on this requirement that you have this, but how, as the licensee, you're going to ensure that you have quality control. And that kind of goes back to the due diligence with saying, how do we make sure that you have the ability to do what it is that we're asking you to do? And so that's important kind of things, how these things tie together, that you have these things, checks and balances for each party to ensure that the things are done the way you need it to do. Territory, where can this IP be sold? A lot of times that's really important. And I think a lot of times this gets glossed over, not just with regards to the deal between the licensee and the licensor, but you want to make sure that it's not, you know, doing something with regards to another contract that one of the parties have. So you need to make sure that there's no breach of other contracts because of this deal. And a lot of the times that goes to territory. So sometimes you can only sell in Texas, because there's agreements that in Arkansas, you have another licensing agreement that's only in Arkansas. And so then if you sell in Arkansas too, then you have caused a breach of another contract. And so we don't want that to happen. So it needs to be very clear in terms of territory, what you can sell. And then exclusivity, how many people have access to this IP? As a licensee, they're going to probably want a lot more exclusivity. They're going to want to show that, they're not just getting, that they have some exclusivity because they want people to buy specifically from them. But a lot of times as a licensee, they're not going to want to do that. So there has to be some kind of compromise with regards to who has access for how long, who can sell this kind of thing. For larger brands that may not be as big of a deal, like something like we showed with Nike, who has lots of licensing deals with lots of different apparel in different places. They don't manufacture all of their own apparel. They allow other manufacturers to utilize it, putting their logo on a t-shirt or whatever. They work with schools and those kinds of things. And so that's over there. But to be associated with the Nike brand is a big deal. Therefore, that's not going to matter as much as with a smaller brand, that I think that's going to make a bigger difference. So let's talk about some common problems in licensing agreements. Just like I mentioned before, lack of specificity. You need to set performance expectations and timelines, minimum royalty requirements. You need to make sure that the licensee is doing its job. Contract extension options. So obviously, the licensor is going to want probably a shorter time sometimes, and the licensee is going to want a longer term. So then you got to have your initial term, and then how do you extend those options? If everything is working well. So I think that that's important to have, and that goes kind of in hand with your termination, but also just say, hey, if we like this and it's working well, do we have to sign up a whole new contract, or can we just extend what's there, and how does that work if we choose to do that? So I think to build in some extension options is really important. collection of royalties. To the extent that you can, to get an advance on royalties or minimum payments due, I think works best for the licensor, because sometimes with accounting and sometimes depending upon how the licensee does its books, it can be a really long time for the licensor to actually get a payment. So from the licensor perspective, to be able to assure that they get paid, to have some minimum requirements is really good. And then auditing rights. The licensor should be able to check the accounting and sales to ensure proper payment. You don't want an arduous where it's like every week or something like that. You really kind of have to look at the licensee's accounting practices. But I think it shouldn't be any less than quarterly, maybe at least monthly. I would like to see it, but it depends on their accounting practices. The smaller the organization, probably the less accounting procedures and that they have in place. So you're going to have to give some time that they're probably not going to be able to have a really quick turnaround on a monthly basis. So maybe giving a little bit more breathing room so that they can do the accounting would be better. But at least there needs to be some terms and when the accounting is due. And then that gives you some rights in terms of audit. If we don't like what we see, how can we audit this and what the responsibilities and requirements are regarding auditing. Okay, I know that that was a lot. I was checking my time because I really wasn't sure like how much time I had back. But this is how we connect. We can connect on Facebook and LinkedIn at The Right Lawyer, Instagram, The Real Right Lawyer. I am going to tell you guys honestly, I am on Instagram, but I am not on Instagram. So you can connect with me at all these places, but don't message me because I won't see it. But you just email me would be really good. And so you can go to my website as well, which is therightlawyer.com. So I hope this worked out for you guys. I'm going to stop sharing because I can't see any comments that's going on. And then if you have any questions, I'll be here to answer. Okay, I'm back.
Hey girl, hey. It
Hey.
was so good. It was so good information. I'm just going to answer a couple of questions that we have up here that aren't related to your talk, but I wanted to make sure that they were up on the screen. So I'm trying to see if I can put it up here, but it's not letting me do that. Maybe because we're both on the screen. I don't know. Either way, how do you sign up for CLE credit? Is there a form? So CLE credit is given in Alabama. In your state, you will basically have to take your form and let them know that that's how it is. So there's a form in each state. If you are in Alabama, then you can definitely get credit. And if you need help or any type of advising on how to do it, and I think it says Memphis for you or Tennessee, just let me know and I'll be more than happy to help you. It's usually a form you have to fill out and state that you attended a live CLE with CLE codes and everything, and you turn in your documents. So as long as you fill all that stuff out, you're good. And then how do you access the replays? The replays will be available once we end the session. So that's just two things that I wanted to cover. Now back to our speaker. I don't know why she's not on stage right now. Something must have happened to her internet. Which resources would you suggest learning from? I had to figure out what happened to my speaker. So while I'm doing that, any other questions about replays or other troubleshooting stuff when it comes to this event? Because I want to make sure. Um, yeah, I see. Yeah, I want to make sure that you guys have access to that. So I'm gonna put this question back on stage. Hopefully she comes up very soon, Patricia, and puts her camera and stuff back on. I don't know what happened. All right, Shahara, you're back.
Yeah, sorry about that.
Literally lost you, and I was like,
Yeah, no,
I can't answer these questions for you, Shahara. I really cannot.
sorry, you know,
But
that's
I
personal.
am leaving. Like my camera and stuff is gonna go off, but I'm going to have your video up here, and the question in front is from Patricia from Springfield, and she said, which resources would you suggest for learning?
So one of the things I would say is So obviously, if you can go to some CLEs on just IP and things like that, and understanding some CLE on licensing and contract drafting, like even if it's not licensing specific, but contract drafting, I think um, getting some CLE on contract drafting would be, good, because at the end of the day, it's just a contract. And so you really want to try to get as much understanding about contract drafting and learning how to draft well. In terms of licensing, well, it's just maybe reading some licensing contracts and seeing what they look like. You can go to like Law Insider and kind of see how some of these deals are structured and what they have in there. Those would be some of the ways that I would, make sure that you um, kind of learn. So one, just learning about contract drafting and different elements of contracts and different terminologies and things like that. And then two, reading some IP contracts would be really good to do. And that's how I would kind of start diving into to learning more about licensing and what they look like. And then three, just if you're just really kind of into it, kind of seeing how some big brands utilize IP and how they license and what they do and how they approve their licenses and things like that would be something else I would do.
Awesome. These are really good questions. So, I really want to kind of tackle some questions from the people who have literally been kind of like in the area. And I know licensing comes up a lot in the TV movie production space. And I know there's a law student that registered that's focusing on sports and entertainment law. So, can you or do you have any clients that you can talk about this from a entertainment TV space or sports space?
Okay, I'm sorry, it froze. I don't know if that was me or you. So
Did you hear what I said? You want me to repeat it all?
yeah, can you repeat it? I'm sorry.
Okay, give me a
Everything
second.
froze. It's like I don't know what's going on. Like at least
All
I
right.
got through my talk.
Can you hear me now?
Yeah.
Awesome. So there is a question from somebody who registered that is a law student interested in specializing in sports and entertainment law. And the TV production space comes up and licensing comes up a lot, and what you can use on a movie, what you can use on a TV show, what's not and not allowed. Can you talk about that from a licensing perspective for us today?
So I don't really work too much in the music industry space. So there's probably somebody out there that's watching that can be a better resource, but I'm going to do what I can. Okay. So what I would say is that for any IP, all of it, it's all about permissions, right? IP is just a right to exclude, right? So when you register a patent, a trademark, a copyright, you just have the right to exclude people. And it also kind of shows ownership as well. So you have to get permissions for all those things. So the cans and can'ts really has to do with what you have permission to do. With music, there's usually music clearinghouses that are there. Copyrights, the same kind of things. There's management companies that people that have are in charge of that, who have the right to manage the license and the IP. So everything is always going to be about permission. So really, when it comes to what you can and can't do, it really has to do with, do you have permission to do that? And with any type of IP, my saying is it's better to get permission than to get sued. So if you have questions about can we use this, then find out who the owner is or the management company is and get approval.
Awesome. And I think you have some questions here in the comments. So I'm going to try to put them on screen. Please try to ask the questions in the Q&A so it's a bigger question on screen. But in terms of royalty payments, what is the average for popular sectors?
The app there's it depends on what you do. I've seen stuff in the manufacturing, like toy industry, things like that, that is like as low as 3%. I've seen something, that they're very low, because really what's happening is that they're licensing it, but the company is doing all the manufacturing, they're doing all the marketing, all of that kind of stuff, and so therefore, you really just they're not the licensor isn't really doing much of anything. So I've seen it as low as like 3%. In an affiliate space, something like that, it could be as high as 80%. So I think the industry, and depending upon what it is, that licensing is going to be, that royalty fee is going to be different. So in any manufacturing space, you're going to see it very low, because the person, the licensee, is usually taking on most of the financial responsibility. And so, of course, they're going to want to make sure that they recoup their costs first, before they start paying out.
Awesome. And the other questions I had are into that branding content creation space when it comes to something that's licensed. What are companies trying to do to kind of get that out there that they are, going to start licensing out their product? What do you advise or try to help them with when they're thinking about licensing? And I think Don shared something called licensing executive. So I don't know if you've ever heard of that,
I
but
haven't, but that, I'll
I'm,
look into
I'm going
that.
to put that up on the screen so you can see it at society or LESI.org is
Oh,
what
thanks
that
for that,
is.
Don. Yeah, I hadn't heard of that, so thank you so much
Mhm.
for that. So what I would say is that to reach out to somebody you know, I think it's always better to get started with a company or brand that you're familiar with and you know. That way, you have a chance to kind of test it out and see what works and what doesn't work and what you like and what you don't like. So if you have two business owners that are friends that get along, they may not be in the exact same space, or maybe they are in the same space, that they are able to kind of work together in some kind of maybe co-branding, co-advertising thing. A long time ago, I live in Houston, Texas. There was a carpet company, two carpet companies that kind of came together for advertising purposes. And I thought that they were one company, but they weren't. They actually were two different companies, but they came together to advertise, to do joint advertising, because they were both small. And I thought that that was really smart, in a sense that it, kind of helped alleviate expenses and those kinds of things. I have a client that does a event every year, with a competitor of his in that same expense in that same space that they're in. They do a thing together, and there's some licensing that goes along with that, right? They have to co-sponsor this event, so they have joint a JV. That JV requires the use of each of their IP and those kinds of things. So I would say for a brand to kind of start where you are, your circle, and see how you can utilize that, for your advantage before you kind of go out and deal with strangers that you're not used to, that maybe you're not getting the kind of deals that you want to get.
I love it. I love it. So you talked about licensing, but licensing is really how to use your trademark. And that's literally the top pressing question for entrepreneurs that are trying to be convinced, right, about what their trademark can do because they get it and they're like, well, what do I do with it? I don't know. So,
Right.
literally, how do you make that clear for your customers? Because I know that that's a lot of questions. They don't know how to upsell them, they don't know how to really tell people how to use their trademark. And some of them don't even know the answer themselves. So, this would be really helpful for some of the people that are trying to break into this space and people who are listening.
So I'm a big believer in strategy. I'm a big believer in having strategic plans, and for those of us that represent small businesses, they may not be in that belief system as much as we are, but I believe that, and I talk to my clients about that. Like, what is your plan? What's your plan for the next year or two? How do you see your business growing? What do you see happening? And then seeing if part of that vision, can be licensing. So a lot of times, like I have clients that, we have several marks, but within that several marks, they really just kind of use that in house to build their own brand. They don't license, they don't do anything else, but it's become very synonymous with where they are in that space. And so now I'm saying, hey, we've kind of got this space, not a lot, but we've got a big market share in this space. How can we get more of that market share, right? You're trying to grow, you're trying to move, into another spot. How can we take what we have and utilize that somewhere else? And so these are the ways that you have the conversation. If you're just trying to build the brand in terms of the marketing, so that people can have that identifier, right? Let's just say you're a coach and you're, expert coach A. And so we've got expert coach A mark, and we're just like, everybody hears that expert coach A, and we know who she is and what she does, and we like her products and all that kind of stuff. Then how can you expand that? So maybe expert coach A wants to do planners. Well, does expert coach A have to create their own planners? No, right? You don't have to do that. But there's this particular type of planner that people like, and you even use. So why not even go to this company that you, which may even be a small company, may not be a really large company, and say, hey, I think we should do something together. Maybe we should do a joint venture together. I have these people, they really love to use planners. I use this planner. What if we did a expert coach A and planner B co-brand? And it could be something as simple as that. And so really, I think it starts with number one, you protecting your own brand and building the brand recognition, which is requires marketing, right? It requires dollar spend to do that. When you have that, or at least feel like you've got a good hold on it, then you can take that and expand it a little bit more to things outside of the space that you're known for. And that's really where you get the value, the extra value for your IP.
That is good. So we're about to show the CLE code, but at the end, y'all, we always ask the speakers one thing that you say to motivate yourself, or a phrase that kind of keeps you grounded. You already gave them the way to contact you, so you've already kind of advanced that part. And then we'll show the CLE code. So something to take away, something that you're challenging them to do with this idea of licensing, because so many of us are scared to break into a new niche within the trademark niche. So please give them a challenge, something to help them kind of get excited about licensing.
So I would just say, what do your clients need? I started doing trademarks, well, I started registering trademarks maybe about 7 years ago, because I was telling my clients, go to this other lawyer. They do trademarks. I don't do that. And then my clients started to come to a point of like, no, we're not going anywhere else. We want you to do it. We're used to you. We want you to do it. And so I really had to learn how to do register trademarks, right? File out the application, because my clients just really weren't into going to somewhere else. They weren't happy about that. So I think it's the kind of the reverse is true, is if you're finding that your clients are not really feeling comfortable going with another attorney, going somewhere else, going out there, then the question is, how are you going to serve them? Maybe it's not so much that you have to do it yourself, but do you have somebody that you can bring, or a contract attorney, or somebody that you can work with to assist your clients with this, that will make them comfortable? So I think really your expansion or contraction, as you will, of your practice has to do with what your clients want and need. And it doesn't mean that you have to do everything, but I think you should at least be understanding and knowledgeable enough about this issue to be able to help your client build their business. And I think that as business lawyers, whether you just specialize in trademarks, or you do more, really have to help our clients see how they can add value to their company, because as long as their company is doing well, they'll pay you.
I love it. Take us off the screen. I love it. I love it. I love it. Take us off the screen. It's time for your CLE code that you've been patiently waiting for.